You're listening to State of Arrest with South Florida criminal defense attorneys William Moore and Billy DiRenzo. Today, to blow or not to blow, that is the question. Should you consent to chemical testing if you're being investigated for DUI? Bill?
How you doing?
Hey, how you doing?
Good.
Has the answer changed since the hard time rules have changed with regard to the automatic license suspension of 30 to 90 days?
I don't think the answer has changed because, generally speaking, people, when they get arrested and they are presented with that question, they don't even know the ramifications of it. They don't know that on a first-time offense, and only on a first-time offense, if you give a breath test or you refuse a breath test, you can then go into the DMV and you can get an automatic hardship license, which will be good for the entire length of your suspension. Usually they don't know that.
That wasn't the case as of 2013, I believe?
2013, that changed, yes.
Before 2013.
Before 2013, you had to apply for the formal review hearing. After 2013, you can go in and get an immediate hardship license. But if you've been previously arrested, that doesn't apply and you have to go and get the formal review hearing.
Okay. In the past, though, and when we talk about hard time, in the past, if you refused, you're looking at 90 days with no license whatsoever.
That's if you lose the formal review hearing, yes.
Right, but now you can automatically, by waiving the formal review hearing, you get your license no matter what. So I would think that would kind of go in favor of refusing at least the first time.
Yes.
Because we don't want to advise people to advise the second time because that
Yes.
would be advising them to do something illegal, right?
You got it. Because if you refuse for a second time, you can be charged with an additional crime of refusal to submit to testing. And obviously, as criminal defense lawyers, we cannot advise anybody or counsel anybody to go out and commit a crime.
And depending on the judge, I guess that can really screw up your chances of defending the DUI. If you've got a highly defendable DUI, but there's a second refusal tacked onto it, they can just hammer your client on that one, right?
The prosecutors often like to hold that over our heads because a refusal charge is much easier to prove than a DUI. They have to essentially prove that you have had a prior refusal and you refused this time. A lot of times our defense to that is going to be probable cause to determine whether you were properly arrested for DUI.
I've always had a problem with that law because if you were to take it to trial, the state's got to prove beyond and to the exclusion of any and all reasonable doubt, the highest standard,
Yes.
that the officer had probable cause, which is a different standard.
It's
kind of weird, right?
It's very weird, yeah.
Yeah, it doesn't seem
Yeah.
to make sense, but then again, how many times have we said DUIs are the epitome of the erosion of our constitutional rights as the law seems to unfold?
Yes.
So what's the answer, Bill? Is there a straight answer?
Listen, everybody asks, they probably ask you, they ask me all the time, when we're sitting around talking and like, well, Bill, what do I do if I get pulled over? Do I give a breath test? Do I not give a breath test? And a lot of times the answer, for me anyways, looking at it from a criminal defense attorney's perspective is, most of the time you can work with a refusal. Your clients come in and usually they're going to give you an intelligent reason why they refuse the test. The things that we hear most of the time is, hey, look, I know a police officer and they told me never to blow. They told me that the machines aren't accurate. They told me that they're a trap. Essentially sometimes they say, look, I cooperated with this guy. I should not have been arrested, so I wasn't cooperating with him anymore.
They can explain away. The clients can explain
yes.
away even though it's being used against them.
That's a
I
much
agree,
better
100%.
way to put it. The prosecutor is going to come in there and argue, and they're going to say, oh, well, they refused because they had too much to drink. Is there any other reason? Obviously, why would somebody refuse if you haven't had too much to drink? Then obviously we have our reasons that our clients come up with for us. But then on the other hand, we say, well, should we give a breath test? And I think the answer is different for everybody. It's like, if you know you've had too much to drink, then that is going to be some good, strong evidence against you. If you give a breath test and it is above the legal limit, that's going to be good, strong evidence against you. Can we rebut that evidence? Certainly. We're going to need some other evidence to rebut that breath test. And who knows, maybe sometimes we'll find a problem with the machine. Sometimes we'll find a problem with the way the breath test is administered. Sometimes we'll find a problem with what they call radio frequency interference. Maybe there's something in the room that shouldn't be in the room. Sometimes there's a problem with the breath technician's permits, the way the test is administered, the maintenance
Observation
of the test.
rules, vomiting, if the suspect vomited prior to testing, the presence of that in the mouth and getting into the machine. Sure, there's all kinds of things to combat. It's
Yes.
better not to have to deal with it because really you're just getting back to that level. If you don't have it, explain it away rather than try to get it on a motion to suppress.
You got it.
Right.
Yep.
or explain why the machine wasn't working to a jury. Unless, of course, if you've got somebody that just looks great on the video and their blood alcohol level pursuant to the Intoxilizer 8000 is through the roof, you've got that disconnect case, and the jurors start really raising an eyebrow as to how that occurred.
Oh, there's a huge eyebrow that's raised. Yeah, I had a trial on that a few months ago. The guy was double the legal limit.
I remember.
He looked nearly perfect on the video. He looked nearly perfect, and that is one way that we can combat that high breath test, because as you said, there's a disconnect, meaning, hey, this does not make sense. How do we have somebody on this video that looks so perfect, but yet you're telling me his breath test, he's twice the legal limit? It doesn't make sense, and a lot of times, in my opinion, and it's common sense. Somebody's going to look and they're going to say, well, I see that video, I see him walking, I hear him talking, he looks absolutely fine. The breath test is above the legal limit. A lot of times they're going to believe the video, and if they're not convinced beyond to the exclusion of every reasonable doubt, they got to find him not guilty, and that's what happens a lot.
Right, absolutely. I think that most people out there don't realize also that it's not really a .08 per se. That's where the presumption of impairment kicks in.
That's right.
But we've seen arrests where it's a .05.
Oh, sure, it could be below.
And above.
Mm-hmm. Sure.
Right? Those are crazy. I mean, those are winners too, but the person's still got to go through paying an attorney. And if you got the Intoxilizer evidence, it maybe not in those cases, but in most scenarios, we've got to fly down the expert, right? Fly down our expert to testify in this stuff, and it becomes a more complicated case. But most of the time, I think the first time, as a general, especially if you know you're impaired.
Oh yeah.
Don't put your lips around that device. Don't submit to chemical testing. Don't blow into the machine. Flat out refuse and explain it away.
Yeah.
But
I agree with that.
It's everybody's choice, right?
That's true.
Sometimes that'll work against you.
And I think the way it's phrased is, obviously when you sign your driver's license, you are giving them consent that you will submit to any sobriety test that's required by law. The only one that's required by law is a breath test. If you're legally arrested, you are then required to give the breath test as you signed for in your driver's license. So you don't really have a right to refuse the breath test. However, you do have an option to refuse the breath test, but when you refuse the breath test, there's going to be penalties for that. And that's where the implied consent law comes in, and that's where they tell you, hey, if this is your first refusal, you're going to lose your license for a period of 1 year. If you've previously refused, it's going to be an 18-month suspension, and they also advise you if you've previously refused, you can be charged with an additional crime of refusing.
Bill, thanks again so much. You've been listening to State of Arrest with South Florida criminal defense attorneys William R. Moore and William Dorenzo. Next week, we're going to get into why, or at least what the rationalization is for making a second refusal a crime and not a first refusal when it comes to DUI investigations. Until then,